This meeting together, the local planning agency, February the 15th, 8:35. Before I get started, though, I'd like to thank someone who's been the chairman of this board for the last 2 years, Don Colapetro, and like a nice round of applause if we get
Don.
a job well done.
Thank you.
And for the rest of the board members here. Okay.
If I may, congratulations to our new chairman, Sam Vincent.
Thank you, thank
Good
you.
luck.
Well, we have some issues on board that should, I'll leave that. Roll call, please.
Chairman Vincent,
Here.
Don Colapetro,
Here.
Bob Mills,
He's absent.
Henry Bird,
Here.
Bob Thinis, Rex Sims,
Here.
Fred Forbes.
Here.
The first order of business is to elect a vice chair to the local planning agency, and I have a person who would,
I'd like to nominate Henry Bird.
That would be good.
second on that?
I will second that, yes. Yep.
Henry, you okay?
Sure, I'm okay.
Okay, Henry Bird will be our new vice chairman. Congratulations.
Thank you.
What we're going to review this morning are three different items here. One having to do with an amending Division 37 and other parts of the Land Development Code. And Audrey, if you could.
Thank you. Let me just start the record. For the record, Audrey Vance, City Attorney. What we have here is your final review for consistency with the Bonita Springs Comprehensive Plan on an ordinance that is going through the adoption process right now. This is, and I'll read the title block into the record, an amendment to the Bonita Springs Land Development Code, Chapter 4, zoning, amending Division 37, Subdivision 2, temporary uses, amending Section 4-3041 generally, amending Section 4-3046, temporary use of mobile home, amending Section 4-3047, temporary telephone distribution equipment, and Section 4-3048, ancillary temporary uses in parking lots, creating Subdivision 3, mobile food vendors, creating 4-3061, applicability of division, purpose and intent, 4-3062, definitions, 4-3063, permit required, 4-3064, general standards, 4-3065, prohibited locations, and 4-3066, temporary event use permit, providing for conflicts of law, severability, codification, scrivener's errors, inclusion in code, and an effective date. City Council heard their first reading of the ordinance on February 6, 2013, and will have their final and second reading and public hearing on February 20th, 2013. The ordinance is sometimes referred to as the Mobile Food Vendors Ordinance, but before we talk about mobile food vendors, the ordinance does do some things in addition to that, and that is it does make some amendments to our temporary uses. Over a term of years, we've added new temporary uses. We've made some modifications, so it's making this section consistent with some of the other ordinances, including sale of fireworks. As far as revisions to the insurance requirement, revisions to damage to public right-of-way. One of the interesting condition changes was something made by code enforcement of when you may use a temporary use of a mobile home on a single-family residential. If there's a fire, it read fire or disaster. Well, for some people, that could be an interior decorating disaster. So we wanted to make it very clear we were talking about emergency events, at which point, if you had a bad wiring and you needed to get out of the house and use a mobile, for life safety, that's probably a disaster. Something that you just want to live there for a time being while something else is going on in the house is not necessarily a disaster. As far as that, some clarification that sometimes you will need to have permits in conjunction with the temporary uses when there's ancillary temporary uses, and also that extensions, we had it so that we took the language originally where it would go to the hearing examiner. We've now deleted that language, and it's done and consistent with the actual permit for with temporary telephone distribution equipment. So that was modified. The big modification, of course, is subdivision 3, the mobile food vendors. You have the language here. Since you last saw it, it has been very much refined and changed. Alexis Crespo can go over those changes if you would like. And then at the end of the presentation and after public comment, I would request that you find it consistent with the comprehensive plan and move it to, so that I can provide that information back to council, if you do find it consistent. Alexis? You want me to pass that out?
Good morning. For the record, Alexis Crespo with Waldrop Engineering.
Good morning.
Good morning. I prepared a chart to help us run through the updates since we last viewed the draft ordinance at the December meeting, I believe. So I'll be starting on page 5 of the draft ordinance. Okay, so starting at the top of the page with the highlighted text.
Thank you.
One of the first changes made, and this was also a code enforcement addition to the ordinance, is to omit very short-term vendors from this ordinance, meaning those mobile food vendors that are stopping at a location for less than 30 minutes, basically those truly transient and mobile vendors, such as your ice cream trucks, the sandwich trucks that service construction sites, or really any mobile food vendor that doesn't plan on being stationary for long periods of time are going to be exempt from this ordinance, and we feel that adds additional flexibility and will also help alleviate some code enforcement issues with those short-term vendors that could result from adoption of the ordinance. Moving on, we also created a provision for grandfathering some of the existing mobile food vendors in the Old 41 area. That would be the second paragraph under applicability. As you can see in your chart, we did create an 8-year exemption for property sites that have been undergone substantial improvements, meaning $10,000 or more of improvements to allow for a mobile food vendor on the site with a 2-year extension. So basically they could stay up to 10 years through an administrative process on the property. Now that exemption does run with the property, not the mobile food truck. So if we're talking about Hungry Hound Dog, in that case, another food vendor could come into place if that specific vendor chose to leave the site, and they can stay there for a period of 8 years, and with community development director approval could extend that for 2 years. They would also be subject to the non-conforming use regulations, meaning if they suspend that use for 6 months, then it would be a non-conforming use at that point. We did hear from Mr. Pugh at our first reading to council, and he was accepting of this proposed language. Moving on into definitions, one of the holes in the ordinance at our first reading was a lack of a food stand definition, which some of those more stationary mobile food vendors are treated as really. And so that definition reads, a temporary non-motorized food unit with limited infrastructure which serves food and or beverages intended for immediate consumption and do not provide indoor seating. So differentiating between those mobile food vendors that aren't in trucks or carts. And that reference has been added throughout the ordinance. The next set of changes come on page 7. Getting into some of the main concerns that you had voiced at the previous hearing. One of those was that an interlinked issue that there should be mobile food vendors permitted on vacant lots, and that restroom facilities didn't need to be provided by a principal operational use on the site. So that was one item that we did revise throughout this ordinance. That requirement was at the bottom of page 7, and we did remove that requirement for restroom facilities to allow them on the vacant lots. Another change was for the letter of no objection. That's on page 8. I don't believe it's highlighted here, but it's number 11 at the bottom of 3063 on page 8. And that used to read that letters of no objection would be required from all adjacent property owners if you wanted to do this use. We modified that to say you only require a letter of no objection if you're within 500 feet of a school, daycare, or restaurant. And we actually did add residential use to that per council's direction during the first reading. So they won't be required to get a letter from everyone if they don't have those specific uses around them within the 500 feet radius. Following up on that restroom change, at the top of 3064, also on page 8, number 1 used to state that there had to be an operational principal use on site, and we did remove that language to again allow them on vacant lots. Under maximum duration, there was some concern that the maximum 3 days per week was not enough. Based upon discussions with city management as well as council, we have revised that in this draft version to a maximum of 5 days per week. And I'll remind you that the permitting process allows 2 separate locations. So if they had those 2 locations as part of their permit, they would be able to vend for 5 days at one location and then move on to another location for the remainder of the week if they wanted to be vending a max of 7 days per week in the city. So this allows them to be constantly in use and extends that duration. But again, trying to keep them somewhat mobile in nature as is intended by this use. Old 41 redevelopment district. This was a main sticking point, I believe, at our previous hearing. We ran that up the flagpole with city staff, and there was not a proposed change to that. Certainly, if it is the recommendation of the LPA, that will be put into the ordinance that goes to council. But the feeling again is that because of the economic goals being underway in the Old 41 district, a certain amount of time is needed to support brick and mortar and attract permanent redevelopment before we introduce the mobile food carts, which certainly do create some competition for those restaurants in that area. Maximum mobile food vendors per lot. That's the other one that we did not make a change to the ordinance since our last hearing. The proposal's 1 per lot, and that's how it remains in this draft. Setbacks from churches, schools, and restaurants. We had a minimum 500 foot with no ability to mitigate that separation. We have revised the document to allow those mobile food vendors to be within 500 feet or closer to those types of uses, so long as they can secure the letter of no objection from the restaurant, church, or school.
We've also added residences in there.
Yes, thank you. And then separation from other mobile food vendors. We had a very significant separation of 2,500 feet to prevent too much clustering of the use and oversaturation of the use. We did go back to our case studies and the research we've done, and we significantly reduced that to 200 feet with the feeling that if they wanted to be that close to each other, they certainly have the right to do so. And this really does follow what most other cities we looked at provided for minimum separation between mobile food vendors. Oh, I guess that's all. That would pretty much conclude our changes. No changes were made to the temporary use permit process for special events. Again, during special events in the Old 41 redevelopment district, mobile food vendors would be permitted by a special event permit, so that would remain in the ordinance as well.
Thank you very much. Questions from the board?
I have a question. I think this is probably for Audrey, but once we implement these and we find out over time that necessary to be revised or make some revisions to it, how will those revisions be made? Will they have to be by ordinance or resolution, or does John make them administratively, or how does all this happen?
And yes, I think that's a great question, because over time, it's anticipated that our viewpoint, especially in the Old 41 area, is going to change. And just like
Yes.
any other ordinance, the Land Development Code will change over time. And it would be most likely, of course, I need to know exactly what you're talking about to be able to figure out which future change. Of course, we don't know which future change. So I would say it would probably be by ordinance. If it's in the ordinance, of course, council as well as staff cannot, they can do variances to it if it makes sense. But, let's say they decide they want to have only 2 mobile food vendors instead of 5, or maybe they want to have 20 mobile food vendors instead, they'll have to make those modifications, by ordinance.
Okay, so it's going to go through the whole ordinance process, 2 readings and 30-day wait after adopted and so forth and so on. So it's not going to be an immediate thing. Okay, my second question involves a definition, and I think it needs to be cleared. And my question is ice cream a food?
I tend to think it is.
Well, our definitions are very vague there. It does not mention ice cream or ice cream trucks or anything,
Well,
whether they have to have the liability, the insurance and
Well,
so forth.
Right, but what we do have in the ordinance is not applicable to mobile food vendors that are clearly in transit. In other words, they're making stops at different locations inside the city of Bonita Springs for less than a half hour per location. So if you had an ice cream truck, there is a definition in the Land Development Code, and it was some kind of sundries, and I had to look it up before. I know, I'm looking at Debbie because Diane and I have talked about it in the past. It's like ice cream novelties, or they don't use the word ice cream, but something very 1920s kind of sound in the code. The ordinance does not apply for that type of thing. Now, if it was something, let's say, another ice cream vendor put a stand up, and that stand was staying there for all day, they would be under this ordinance.
Well, and that raises the question then of an ice cream truck that's portable. Does it have any permit requirements or insurance requirements at all in the city?
Pretty much no.
That's worrisome, isn't it?
It's worrisome, but at the same time, they're not only in the city, they're operating all over. Now, we did do some research, and I'm sorry I don't have that available with me right now. I think the concern is if there's an ice cream truck, and let's say the ice cream truck buys its ice cream from someplace near Tampa. And John, do you remember the instance?
It depends on how it's going to be prepared. Are you purchasing packaged ice cream? I mean, Audrey had referred to the novelties. So if you go out and buy the Mickey Mouse bar and you have those pre-packaged that you've purchased from a commercial facility, and you have a push cart that you're walking around and you're never in one place for more than 30 minutes and you fall under that truly mobile section, you are still regulated by the state in terms of the cart itself, how it's stored,
Temperature.
how you operate. So regardless of whether there are city requirements included, there are also state requirements.
I see. But for a truck driving around town, there's no permit and there's no insurance requirements, and we don't know who this person is, or there's no.
Locally, we do. The state does know, and the state inspects the facility, approves the facility, approves how they obtain, store, and sell whatever ice cream products they have.
And who inspects that? Does the city have any role in inspecting those permits or anything?
No, sir. It depends on the type of facility you're talking about. It's either the Department of Agriculture or the Department of Business and Professional Regulation.
And I just want to point out, what we're talking about today is a land use ordinance. So it's about physical use of land in our community, something that is just interstate or is traveling through the city. It doesn't make sense to put it in our zoning, aside from the fact, I think, from a legal challenge basis.
Well, I was
Not
curious
something
as
you
to
really
the
can do.
insurance requirements and so forth of people driving through our community, and if we have any control over them at all, or any requirement over them all. Well,
It's a very good point, Mr. Sims, and I think that it's easier for the state of Florida to regulate those businesses than it is for even Lee County or the city of
Okay.
Bonita Springs, simply because they are transient in nature.
Right.
So, John, but take it that someone is out there to enforce the licenses and so forth.
Yes, sir.
And that's usually state.
It's usually state. If you start falling under the definitions that we've included here, that's when the city becomes involved, but not until they cross that threshold.
Mr. Chairman, Rex, in response to your first question, though, ice cream is not a food, it's a gift. But I have trouble believing that some of the vehicles that I see traveling the streets of Bonita have any kind of insurance or any kind of inspection. I mean, you can't see out of the windows of those things.
Sure.
Not that they're not performing some type of service, in the neighborhoods that they service, but I really find it hard to believe that they've got any kind of
Right,
coverage or
cities are
inspection
preempted
whatsoever.
from doing motor vehicle regulations. I mean, for the most part, we're allowed a few exceptions there, but for the most part, we're not allowed under state law to be regulating people's insurance in their vehicle. We're not allowed to regulate the tinting of windshields, the noise level inside vehicles, although I'm questioning whether the state can regulate that right now, but that's a different case that's out there. That's something that is under the Uniform Traffic Control Law, so we could
Okay.
take it to the legislature if we really think there's a problem.
Don't vehicles have to be, in order to be registered, don't they have to have insurance? Isn't that, I mean,
Start with.
Well, that's $10,000. PIP is generally all required. Here, in
This
this
is way
portable
outside
food
the
vendor,
scope.
we're looking at something like, what, $500,000?
Right.
Which is a bit of a difference in the case of a need for those insurance
Sure.
to kick
Okay.
in.
So what you're saying, Audrey, is that the city can't get involved in that because of state statute?
That's correct.
Okay,
Okay, I have one other question, Mr. Chairman. I guess it's on this page 9 of 11 where it says maximum duration. So do I read that, do I understand that to mean that the Hungry Hound Dog has to move that vehicle?
Hungry
Every
Hound
week?
Dog falls within the exemption.
He is
language.
exempted, okay.
Well, that it does not apply to that particular facility because of the fact of how much they put into site improvements, that they're able to stay without the ordinance. Now, let me make that clear, too. When I say it doesn't apply to him, it would apply to him if he moves to another location, if he's at
Okay.
that facility. That belongs to the property owner. It does not belong to the
Understand,
vendor.
okay. Just wanted to see if that was covered. Okay, thank you.
Let me ask, any other questions?
no,
Let me ask a question about when they're given a license to a mobile food vendor. What happens when there's a disagreement between the landowner and the mobile food vendor, and the landowner wants him off the property, and he's got a license to be there for a certain amount of time? How is that handled?
That to us is a private issue between
Okay.
the landowner and the vendor. I mean,
So at that point, then the license becomes null and void.
well, or they find another location.
Right, okay. But they can but they can't take that license then to another location. They have to reapply.
No, they'd have to apply under that location, the new location. So, I mean,
reapply.
but I would believe that we have the number 5, so they would be eligible for that position.
Okay, thanks. Any other questions?
are we ready for a motion?
I think we are, yes.
I make a motion that we approve this as amended.
Second?
I'll second it.
Okay, the motion passes. Any opposed? Should have asked that first. None? Too late.
You're a rookie.
Okay. Now-
Did you ask for public comment on this?
Well, I'm getting ready, no, I did not on this issue.
Anybody on mobile food vendors have any comments, even though we voted? Okay.
Sorry. Public comments is next. Any public comments?
Okay, and I believe what the intent of how the agenda is drafted is after we go through the title block, maybe do some discussion, before you vote on an item, we actually do the public comments on
Okay.
that item. So the next item,
Understood.
okay. The
Next item, reviewing for ordinance, the social services.
Yes, and this one, I'm not going to read the whole title block because you'll have one more time where I will read the title block. That will be on March 14th when you review for consistency. This is the final draft after changes were made from our last meeting, along with the changes that were provided by Ms. Grady and Mr. Pritt, along with some changes by Ms. Crespo and myself, on the ordinance that is creating the supplementary regulations in the Land Development Code. You have it before you. The draft you have is January 31st. first. I just want to check to see if that is the most current draft. If not, I'll let you know if there's changes. Yes, it looks like it is. Get my system up. At this point, if you have questions on it, we can go through it page by page, whatever your preference is.
Okay. Questions, comments from the board?
Do you want us to go through like a short explanation of each area?
I have a question whenever it's a good time.
Okay, let's get the question first, and then,
Well, first thing I want to talk about is this Lee County Homeless Coalition information release. This is the best thing that we've had since we've been working on this program. And it's 6 pages here. And it very definitely breaks down in minute detail who we're dealing with here. And I wish we'd have had this back in the beginning when we started, because it would have changed my opinion on some of the factors of it. It breaks down to male, adult, white, non-Hispanic with a high school diploma, unemployed and not veteran, food stamps, a major income, and so forth and so on. That's pretty divisive, and I'm really happy to have it. The major thing that's wrong with it is, and that's the thing this board needs to know more than anything, I think, is the question is, how many of these 842 are in Bonita Springs? And it's completely misses the point there.
Well, there is nobody in the city or any social service group that is doing that count. So I can't get you that information. I mean-
Well, this 842 includes Bonita Springs.
That's correct.
And so, and the breakdown is very concise and very complete, except to area. And so, one of the things that we've discussed from the very beginning, when we first started working on this project, is how big a facility do we need, because how many are here? And we know there's 842 in the area, but it's completely devoid of the information of how many are physically here in Bonita. So
I think the question is best answered by the planners. John Dolmer can probably explain how he extrapolated the number to get it, the recommendation in the ordinance, because the ordinance, and actually I believe that's in the operational ordinance, we have a number extrapolated based on, I believe, the 842.
There's been a number of agencies that have done counts for Lee County. To our knowledge, there's really only been a couple that have been done for the city of Bonita Springs. The issue with each of these is how is homeless defined and how were they performed. I don't think any of these are 100% correct, and I don't think the people that perform these studies believe they're 100% correct. What you have is a population that could, at any time, decide they don't want to be found. So it's very difficult to come up with a number. So what we've done is we've taken the best information that we could find for information that was on the county level. We broke it down to try to provide a percentage of residents of Bonita Springs compared to the county, and then with that number adjusted it to a certain extent down for two reasons. One is most of the social service facilities that deal with the homeless in Lee County tend to be either in Fort Myers, North Fort Myers, or Lehigh Acres. So knowing that most of the population that is at least being served is in those areas leaves a disproportionate percentage here. And the second was two studies that have been done in the city of Bonita Springs. One was a study done several years ago by the Sheriff's Department, and another one was by the Coalition for the Homeless, the Lee County HMIS. And both of those showed in the neighborhood of 18 to 30. I'm sorry, the what? 36? 18 to 36. So what we did was, based upon this information, we used ART to account for what could be here and what we can anticipate in the very short term, which is why we had come up with a 30. It seemed consistent with the numbers that we were seeing proportionate-wise. It seemed consistent with the numbers that of the 2 studies that we knew were done here. But like I said, you have to take these studies for what they are. They're done as well as those performing them can be done, but they're not absolutely perfect.
Okay, John, and I agree with exactly what you're saying. It's a difficult thing to ascertain. But early on, we had testimony here, and I don't remember where it came from exactly, but it was some kind of survey that the school did. And what was interesting to me was the number of school children in as I took it was Bonita schools that were essentially homeless. And see, we have no way, this breaks out children and so forth, but I would think that the school survey would probably be more accurate than the one that was done in midnight on January 27th.
I would say that there are portions and aspects of the study done by the school board that would just inherently be more accurate. They have the children in one facility. They're easier to ask a question to get an answer from. But keep in mind, the difficulty with that survey is not the accuracy, it's the definition. Because their definition tended to be a much broader definition of homelessness than what we have discussed both here and throughout the regulation. So they included temporary homelessness, possibility of being homelessness, and living with neighbors.
So it's a broader
It's a much
definition.
broader definition,
Yeah,
yes, sir.
same way with free lunch and so forth, there's a much broader definition.
Yes, sir.
All right, I hear you. Okay, very good.
Mr. Chairman, at the last meeting we had, I think I asked the esteemed legal counsel if it would not be helpful to get an accurate count right now, or as close to now as you could, of the real homeless per the definition of homeless by HUD. I believe that he indicated it would be helpful to justify some of these things that we're doing, how many shelters you're going to have, the size that we have is reasonable for the need. I would make a motion that the LPA go on record to City Council urging them to get an independent, not a biased, an independent agency, expert or whatever to do that work. and
If I
get it
may,
done.
Mr.
Yes.
Forbes, I contacted Ann Ornell, Lee
Okay.
County Human Services. She's
Okay.
in charge of that department. When I sent the memo or email to Janet Bartos, I asked both of them for their information, and I provided you with all the information I have received.
Right. But what's wrong with getting a new count?
We're under a time frame for a
No,
moratorium.
not
and-
for, not, if we got it in 6 months, it's simply going to be data that if there is a court challenge, that will
Oh.
be useful.
Sure. I mean, anytime we get more data, it'll support anything that we're doing, sure.
We have woefully little accurate data on what we have in Bonita Springs. Rex said that, John agreed with that, that's all, that's my point.
No, I think we all agree with that. I mean, this is one where we need to extrapolate the data based on the data we have.
But we don't have good data to extrapolate from, for Bonita Springs, that's my,
Well, Fred, you bring up an interesting question, and John mentioned the problem with the definition. And I think that that's one of the things we're stumbling around here, is that who defines the true homeless person? But I see in the write-up here that HUD has a definition.
That's what I
that probably, whether it fits us or not, I do not know, but it is a universal definition, and I would suggest that any information that would come to us as official information should be substantiated by the HUD definition, and that way we know we're all talking about the same thing. And we may not agree with HUD's definition exactly, because I don't know what it is,
Right.
but at least we would all have a common area that we would be talking about the same set of circumstances. That seems to be so simple, but I'm quite sure it's very difficult to do.
That was what I included in my motion.
But I have a question. How are you going to narrow down this specifically for Bonita Springs?
That's what the independent agency, not an advocate, would do. I mean, it's not an impossible task. If we don't do that, if we ever get a court challenge, you're going to be looking at this data, and that's what you're going to be using it. Well, R30 is what we need to serve and all that. And I'm not proposing to slow down the process at all.
Thank you.
Let me ask a question here, I guess, maybe from John. There's a lot of information in this, the green sheet here, having to do with number 16 for the number of beds and the increase in the number of beds. And then at the back of this document, there are a lot of definitions. Anywhere in here, does it include a definition, say, that HUD has given us for the homeless and so forth? Or we have definitions in here that are helping us move forward?
No, sir. I think that what we had done was taken use the data the best way we knew how to establish a number of beds for a facility. And once you get past that point, once you have established that, or this LPA comes up with a recommendation, the city council adopts it. If a facility is operational, it would really be their review as to whether they accept someone. If someone shows up to their doorstep and says, I'm homeless, do they question them to state, are you really homeless, or what type of homeless are you? I don't know. We really hadn't gone into that because it seemed more of an operational.
Well, as you've talked about it and deliberated this, the way that you calculated the number of beds in this document right here, how was it done? What were your thoughts on that?
In terms of the calculation?
Yeah.
It was a situation that, like Mr. Sims and Mr. Forbes have said, you have data, you know that it's imperfect data, and what we've done is try to apply as much reason and common sense to it as we were able to. But when you're finished with the calculation, you still have something that we feel is solid, but we know and don't pretend that it's perfect.
Well, I know what's perplexing to me is that, we've heard conversations, several of the workshops having to do with the number 20 and then the number 30. 16, I'm just seeing here. So I'm wondering, could any of that be correct? Is it based on the numbers that are in Bonita?
Any of it could be correct. None of it could be correct. I think that they all serve their purpose. The sheriff's department probably has a pretty good feel for certain areas that tend to attract the homeless, and so they probably went to those locations to count who was there. Now, when they did it, how they did it, whether people heard them coming and were scared and ran off, I don't know. But
do you think that the number 842 in this information release is something that was compiled as a summary or an addition of all the numbers that they calculate from each of the areas?
I think this was the number that they compiled based upon individuals receiving service, locations that they knew tended to attract the homeless, and other information they obtained from those they interviewed.
So it's possible that the different areas were individually listed, and perhaps Bonita Springs, someone did a study here to get that number in this total number.
Yes, sir. And what makes this frustrating is if I were to have all the necessary people that I needed tonight to go out and do a study, and we covered the entire city, and I gave you the number of, just for the sake of argument, 25. And tomorrow night, we were to do the exact same thing. If there were individuals living on the south side of Bonita Beach Road, out east of Village Walk, and they were sleeping on the south side tonight, and tomorrow night they slept on the north side, they would no longer be in the city of Bonita Springs. So your number is no longer accurate. And based upon the transient nature of the population, that's why I think you have a basis for all these numbers, and I think that there is a reason to have a certain amount of faith in all of them. But you have to know going in that based on the population, based upon the difficulty in counting these individuals, and based upon the fact that they may or may not be in the same spot tomorrow night.
The point being, they're very transient.
Yes, sir.
John, your number for Bonita Springs, say again, I think did you say 32
Which number?
of the homeless in Bonita that you've calculated here? What number did you?
30 is what we had looked at.
Around 30, and you're comfortable with that?
Yes, sir. And I'm comfortable using that number based upon the information that we have. I
Okay.
cannot tell you that I have gone out to personally count anyone.
Yeah, I understand, but if you're comfortable with the information they have, then that's the best information that we have.
That is the best information that we have. And
Okay.
and Mr. Forbes, I think that you have a good point. Unless you go out there and do it yourself, what do you know exactly what was measured and how it was measured? So I do understand the intent there. If that's something the LPA would like to do and were to have this run a separate course, then the ordinance is before you today. I don't know if it's.
Mr. Chairman, I'm looking at this release, and two things come to mind immediately. And the first one is that this was conducted over a year ago, and that it took approximately 3 months to get the report done from there. So I would have to assume that they have done another count, because it says they gather once a year to do this. So I would have to assume that they did another one in January.
That tends to be the time when most of the
Okay,
organizations.
That's the HUD
do theirs.
requirement.
okay.
Right.
So while that's being formulated, I mean, it took 3 months to put this one together. It's going to take, I would imagine, the same amount of time to put the new one together. Would it not be possible to ask for a more localized count? You know, I mean, I don't know, take the map and draw circles on it, and just,
I don't think that's a bad idea. I think if the data has already been collected, and I believe that it already has been, they probably don't have it broken out in the way that you're requesting. But for the 2014 count and going forward, we'd be more than happy to talk to the county to see what can be done in terms of providing more specific information on location.
I don't have a problem with Fred's motion, but I just don't, for me, I don't know, who would you get to do it? How would you,
You would probably
and I
have
think
to-
we got somebody that's going to volunteer to do it out there, but
In this report.
I don't know.
It says right here, the answer to your question, it says the 2012 numbers are expected in April, so that's pretty close here. So
Right.
But if I might chime in, two things. It's going to be the same way. It'll be based on what's in Lee County.
Right, that's why I'm saying,
And-
but
and-
it's,
And I agree with your point. And the second thing, when, at one of our very first meetings on this subject, way back last year, the lady that's the head of that homeless coalition that has something to do with these numbers, she admitted that they really did not have any good data on Bonita Springs per se. The best that they said they had was this little bit of information, and Sam correctly said it's fairly loose, their definition from the schools.
I don't know that it's a doable thing.
Well, that's what I'm looking at too and thinking about here is that depending on day or hour that you make a study, things can be different. And to have someone go out, pay them a lot of money to make this study and bring us conclusions may not help a great deal. I know what you're after, Fred, but what I'm looking at is you have recommended, I think, 16 beds when you get a permit to do this. And 16 beds is a small number. If they return a number of 0 homeless in Bonita, that would make a difference.
Right.
I don't know if we'll ever know that. We know we do have some homeless. But spending money to have something that's so fragmented and unknown, I don't really particularly would
Well,
like to do.
I think our former chairman's idea, even that's better than what we got.
Well, that's what I was saying, is that somehow they came up with a summary of numbers here, taken from all the different areas. So if we could extrapolate whatever that was, that might help a little bit.
Mr. Chairman, I agree with you. I think that what you might want to do, if the data's already been collected, you're really
Right.
not going to have anything for 2013 that's better than what you have for 2012 in terms of accuracy or location. But if you go down the path of studies, it is an ongoing process, because what you're saying is you're trying to tie an ongoing number to your regulations. So we would need to set something up with Lee County or some other organization that will provide us regular counts, regardless of whether it's 1 year, 5 year, 10-year periods, whatever. And then after those counts come in, we would need to adjust our numbers in the Land Development Code to reflect any changes in those studies. Otherwise, there's no purpose in doing it.
Is this something that staff could do for us, is to pull that, extrapolate that number and bring that back to us?
To coordinate with Lee County, yes,
Yes.
sir, but extrapolation is not going to be any more accurate than the data you have before you today.
Well, what I'm saying is, what was the number for Bonita Springs? They had to have taken that.
I'm sure they did as they worked their way through the county in some form, whether it was either an estimate or whether it was a physical count. But I don't know if they marked the location of individuals or camps or facilities.
Is that really necessary to know exactly where they were?
Exactly, no, sir, but to at least know that they were within the incorporated boundaries.
Right, that's what I'm saying. Something like that, I think, would be appropriate.
If they have that data, I'm more than happy to work with them to get that before you.
Question.
I don't know if they have it.
Getting to Fred's motion, don't we already have somebody that's taking counts?
Yes, there's a new head count coming out in April.
So would Fred's motion just result in duplication?
No, because the HUD count that's coming out in April is basically for all of Lee County. What you could do is to simply ask the people that are doing the Lee County one, even if we had to pay them a few $1,000s extra, to give us a separate thing just on Bonita Springs when they issue their April. And even if we got it in May or June, it would be better than nothing. I'm not talking about this year,
And
2014.
that's fine. And just so you know, Mrs. Ginson was kind enough to hand this to me. Last year, HUD, or Lee County Homeless Management Information System, reported there were 36 homeless individuals in Bonita Springs, and there were no homeless families.
Right.
So this type of information, if we can get again this year, I'll be more than happy to bring this to this.
Mr. Chairman, I mean, while they're doing it, I mean, I can't imagine, I mean, they have all the people together that took the count. I mean, geez, it
Right.
wouldn't be too difficult to say, okay, Audrey, how many did you count where you were? Because they must have had specific areas. They couldn't have just, maybe they did send them out in a burst, I don't know, but they would have
think
had to
people-
know who was where.
Right, I think they know where the transit camps are. I have an email that I prepared to send to Lee Homeless Coalition, and it says that I'm currently at our LPA meeting. I'm asking, when will the numbers be released for the 2013 count? Is it possible to get data that is specific to Bonita Springs? And they said, asking when they conduct the census, do they mark the location of camps so we know what information is available for the city of Bonita Springs?
Could you add a date when we'd like to get that information?
What date would we like it?
It's not going to come out till April, so- and we've got to move this thing off. the
That's what
dime
I'm
now.
getting at, is we have to move this thing along. We can't dilly-dally waiting on a study.
Right, but I mean, having the data will still be useful if the data exists.
So at the end of the day,
And I'm sending it both to Lee County Homeless Coalition, as you mentioned, Janet Bartos came here and talked, and also to Ann Arnell, who is the Director of Human Services for Lee County.
What
those
about
are-
just asking it as soon as the information is available?
I believe your next hearing date's the 14th of next month. So
Yes.
if we can get it before, ask them to have
Yes,
it
how
before
about
then.
before the 14th?
That would be ideal.
So I'll withdraw my motion.
Thank you,
Okay.
Fred, thank you.
Okay.
We move this along now?
Yep.
Yes. This is pretty long document here. It contains really a lot of information here, a lot of strike-throughs, a lot of things that have been added. Can we go through some of this briefly here in terms of the sections that have been set up having to do with the different groups?
Sure.
Because there's a lot of information, and then there's some definitions at the end that might be important to us. I know that there are some numbers that are important, and expansions having to do with 50 beds, that we have 16 beds going in, so maybe we could take a look at these, talk about those things as we go through.
Yes, sir.
Okay, and let me point out, and it's summarized in the green sheet, the ordinance has two major changes. One is, as you mentioned, is the use group section, which is on pages 3 and 4 of the ordinance. And those are the new restructuring of the use group for social services. And then the second big change, because I'm not counting all the use groups, is once you get into the supplementary regulations. So beginning on page, one second here. On page 47 to page 50 or so, let me go. Page 51, that's your other big meat and potatoes of this ordinance, and that is the supplementary regulations dealing with social services. The other language in there, obviously, I've talked about 5 pages of the ordinance. The other changes in there are changes to the use group, because as we renumbered the use group, we had to renumber the use groups in our regulations.
Yes, and that brings up a question. In my mind, since we have revised the definitions, the ordinance that we're discussing here basically applies to what is now the new Group 4. And that's all.
The supplementary regulations address groups 3, 4, and 5. 5 is governed by Florida statutes, so we've been.
But those others do not have temporary housing. Only Group 4 has temporary housing, and that's what I thought was the crux of this ordinance.
It is, but there are also some uses such as day shelters, soup kitchens, and other types of uses that may have compatibility type
But
issues.
if they don't have shelters, they, okay, if the group doesn't have shelter, like Group 3 does not have sheltering, then this ordinance is basically a shelter ordinance.
The
As I-
operational ordinance is, as written, specifically geared towards homeless shelters. The supplementary zoning regulations that are going into Chapter 4 address both groups 3, 4, and 5, because there's certain issues involved with all those types of uses that needed to be addressed from a design standpoint.
I think that's confusing.
I would defer to staff on
Aren't most
how the
ordinances that
operational
way?
ordinance.
They're designed to be confusing.
From the very beginning, the crux of our discussions has been the housing situation, because we agreed it did not apply to rehabs and places like that. And so we, in my mind, we have been specifically excluding everything except what is now Group 4, which is the one group that has temporary housing. And so, in my mind, that's what we have been working on all this time, and that's what we are going to pass today, hopefully.
And then
Am
we
I
see,
clear?
well, and then we see some strike-throughs in Group 1, Group 2, Group 3, and so
Those are
on.
just definitions.
Yes, definitions of those groups. But it does bring up that point. Could we get I guess, an answer to Rex's point here about these other groups, and why are we discussing those now?
We were, I was asked to also look at certain uses such as soup kitchens, offender rehabilitation, basically reorganize the use groups based on intensity. And that was the direction at the outset of this project to, in addition to homeless shelters, also create supplementary regulations for a variety of social service uses that could, again, need to be addressed from a compatibility standpoint. However, again, the operational ordinance, you are correct, only addresses homeless shelters as currently written.
Operational, right.
The operational.
I'm very pleased that now we have a well-defined definition of the various groups, because before, I think a lot of the discussion we've had in the last couple of months over this has been in areas that we were having a discussion on, which we did not have a clear definition. So now we have that, and I feel very comfortable with it. It's just that I want to make sure that what we're doing here with this shelter ordinance is very definitely pointed out to the group that I think we've been working with. The operational is basically for group 4.
Well, as I read it, and that's, again, I would defer to staff, it specifically is the homeless shelter use within Group 4. I don't know that, as currently written, the operational ordinance would address halfway homes for delinquents, juvenile, correctional, other Group 4 items. It's really limited to one use within the Group 4 use group.
If I could add, when you go through this, and I'd like to see you go through this, is bring a correlation here to these groups and the residential, 1 and 2 family residential districts, the residential districts, and so forth. Just make a little tie there if you could.
Sure. Well, in order to comply with Florida statutes, we realized that Group 4 community group homes could not be excluded from your single-family and multifamily zoning districts, subject to separation and maximum occupancy. So in order to be consistent with your Florida statutes, we did include Group 5 within your residential zoning districts. Group 3 and 4 are not permitted in your residential zoning districts. So
Okay.
that was to comply with state level.
Any questions?
Well, I want to bring up a concern that I have, and that is there's another category of, for lack of a better word, homeless shelters, but they're a homeless shelter by another name, and that is you can have a halfway house, a halfway shelter that caters to the same clientele as what a homeless shelter by the definitions in here. And I think, on the one hand, I think what's been done with the operating ordinance is good, because a lot of things that were in it that were very specific to what we envisioned a homeless shelter to be have been stripped out, probably for the good. Now the definitions, it's so generic that we could easily say that if you have a halfway house or shelter that has the same clientele as you've defined in here for a homeless shelter, that it would also be governed by that operating ordinance.
Fred,
Yes.
you brought up an interesting question, and I think the difference in the new definitions that we have here back on page 54 and 55, I think the only difference, as I interpret it, is the length of time.
That's right.
Because the class 4 is temporary, whatever temporary would be, and what you're talking about is a more permanent base, longer term.
Longer term.
So we come down to the point, is temporary 3 days, or 1 day, 5 hours, or is temporary 10 days,
And all I'm
that's the void that I see there, but it is well established here in the definitions,
Right.
exactly what
Well,
you're
what's
talking
on page 55 didn't make it. In fact, the definitions on page 55 or 55 are quite a bit different in that option B, as it's called, than it is in option A. You could solve some of that by that. The other thing you could do is just to simply make the statement somewhere in here that if a halfway house or shelter has the same clientele as is defined for a homeless shelter, and you could say destitute and whatever else, that it would then be governed by the operating ordinance for homeless shelters. Because the homeless shelter no longer says you have to get out in 30 days. All those things are out of that ordinance. The two would be synonymous to me. And that would close a door where you think you've got the thing covered and it's 30 beds, and here comes somebody in with a homeless shelter with longer stays, and they're proposing 60 or 90 beds and what all. That's my point, so.
You know what I'd like to see here is a little discussion that would include the page 53 through 55, which was not recommended by staff and legal. Fred, I think you
Yeah.
submitted that.
Yeah.
And get a comparison here with what these 6 groups are saying against what we are recommending, the staff is recommending here, and the differences in the two. And because my questions are why,
Right.
Yeah.
you've got these in here, and why particularly number 6 here, which was added.
Well,
Well, before we go there, let me just address Mr. Forbes on this one, which is, I'm looking at, on page 48 of the Land Development Code provisions, where we do talk about halfway homes
right.
for delinquents and offenders. We have a definition for that in the ordinance. What we would do is we could add to the operational ordinance in the applicability that in the event a facility that is defined as a halfway home for delinquents and offenders is actually a shelter, we'll treat it as a shelter.
And you know what?
that's all we need to do is in the
That would- that-
operational.
I would- that's what I've
Just
been
add it in the
advocating.
apply. I think that's all he's asking for, and I think that is something, basically,
Audrey.
if it's walking like a duck,
Sure.
talking like a duck, or
It is a
quacking like a
duck.
duck, let's treat it as a duck.
Right.
And I think that.
That's all
I
I'm,
don't
that's
think-
all
yeah.
I've advocated. So,
I don't
Okay,
know.
that sounds
I really
fine.
would look, it's a different definition, so I think you'd have to really,
Now,
Look,
given
the
that,
capacity is
what
very
about
different.
the 1 through, all these others that you've included, and you say they're different than?
well, if you read, let me say this, I did not write up the definitions. All I said was, because homeless shelters is what we've been working on all this time, it seems to me it could be in its own class. I'm assuming Alexis wrote up option B, but I don't know that she did. But the definitions are different in option B versus A. But with what Audrey has said, she has resolved my issue. You all may have some other issues.
Well, and again, I need to make sure, I've said that just quick off the cuff. We do
Right.
want to make sure, because you're now doing another count. We just spent all that time talking about the Lee County homeless.
Yeah.
That count is one number. That number would not include people in a halfway home.
Well, if they were destitute and homeless, it would.
No.
No.
I mean, a juvenile, if they're,
Well,
if they're determined.
I would exclude juveniles from what you're talking about.
but that's what if you need to look at the definition of
Yeah.
halfway house
Right.
at the bottom of page 48, it's halfway homes for delinquents and offenders. Now, you have a second one, which are self-help group, halfway or self-help group homes for
Yeah.
persons with social or personal problems. So
And
right
all-
now, you've got 2 separate categories.
Right.
And these are usually smaller facilities than necessarily the number at least that's included. So you may want, and these are people that clearly that need rehabilitation that's defined in here, mental illness, addiction disorders. So you might, for a
Right.
halfway home, want some special regulations that are really tailored to that. And that's really a question of whether you want to put that in there at this point.
Anytime you start using the word rehabilitation, you need to think about your Americans with Disability Act and the requirements so that we do not violate ADA.
Would we be violating ADA by applying what's in that operating ordinance now? I don't think you would.
If you apply it towards somebody who is in a facility for rehabilitation, and you would have a different strict scrutiny to show why you have the ordinance, so you have a different standard of review. It makes it much harder for the ordinance to be sustainable.
To me,
Mr. Chairman, Audrey, the halfway house, as we understand the definition, the zoning on that has federal guarantees too, as I understand.
Right, I think I'm saying that.
Okay,
right.
so that lies outside the scope of this operational ordinance.
It's the intent for it to, right, the challenges that you have seen in other communities, whether it's Delray, whether it's, I believe, Bradenton Beach, the facilities that they were looking at, for example, they call them sober homes. A sober home would be something that somebody is in the midst of getting treatment under Americans with Disabilities Act. They're working towards it. They generally tend to be smaller facilities, integrated in regular neighborhoods. That is not something that we have been tasked with
right.
regulating here, nor do I think it would be wise to add it to them because of the amount of federal lawsuits on that particular subject matter.
So Audrey, are you saying that by making this change that Fred was talking about, that it might bring on some other problems?
If he's looking at the definition, and as the definition talks about rehabilitation, and rehabilitation is a protected right in Americans with Disabilities Act, it could be creating a problem.
But I thought that under our definition of Section 4, that it did not include rehabilitation.
I don't believe it does at this time.
So I thought that was what we were talking about from the beginning. We were talking about homeless shelters, and we were not involved in rehab programs and so forth. It was a temporary
Right.
shelter. I'm under the impression that's what we've been working on all this time, is a temporary shelter. And it did not, because we raised a question about rehab places like the Shangri-La and so forth. We did not want to get them involved with it. So this is a temporary shelter program. And I think once we start bringing anything else into it, it certainly clouds the water now.
Thank you. I could not say it as well as you have.
Well, then, based on that, can we look at these, on the green sheet, at these 5 groups that have been listed here? And we've got some underlining, some additions, and some strike-throughs. Can we just go through that briefly? And so we,
What page, Sam?
that's on page 3. This was option A. This was a recommendation by staff and legal. And so I guess, Ms. Walter,
Groups 1 and 2 are, I believe, in both versions, substantially the same. No real changes were done to those. Getting into Group 3 is where we start to make the changes. 3 is where resident facilities, i.e. overnight stays, are not permitted, but are still those types of uses that you would want to address in your supplementary regulations, such as your soup kitchens, day shelters, offender rehab, self-help, outpatient substance abuse, things like that, that may need to be addressed through your supplementary regulations. And I believe option B stays true to that as well. Now, where the 2 options start differing is in Group 4. Group 4, in the option A, is just generally temporary living facilities with people with personal and social problems. Option B reduces this grouping to child or wife abuse centers and adds rehabilitation. Our proposal, option A, includes that use but exempts it from the supplementary regulation. So while this is a temporary living facility, a child or wife abuse center is a temporary living facility with someone with an issue, a problem that needs to be addressed, a social issue, they are exempt from the supplementary regulation. So this was really designed to streamline the groupings, not create additional groupings, and just create an exemption for those handful of uses that maybe didn't need to be addressed in the supplementary regulations.
Incidentally, one of the comments that we got, and Alexis is using the language in the current draft of the ordinance, child or wife abuse centers. I believe I'll be changing that to domestic violence abuse centers so that we are not being gender specific, as well as you could be something where it's not necessarily a child, but all domestic violence.
Well, the question comes up then in 4 is if under Group 4, if there was any kind of a rehab program, then would it take that unit out of Group 4 and put it someplace else?
I've, in the staff proposal, it's in Group 5, because that is, as Audrey has said, is subject to federal regulations for the most
But
part.
Group 5 brings you into long-term. And going back to our original definition, this thing we've been working on for months is a temporary living facility. So once we move into Group 5, we're into long-term living facility. So I think we're riding a different horse here.
well, I believe, Rex, that under Group 4, which is temporary,
Yes.
is different than Group 5, which
Yes,
is
but in the
long-term.
beginning, when we started out here, the mission that I understood we were to have addressed temporary facilities. Because once you get into rehab programs, you take it away from the temporary situation and you put it into a longer term, which would be necessary to have any kind of rehab in my mind. So what I'm saying is, if we have a facility that we're looking at as a temporary thing, but they offer rehab programs, then it automatically, by definition, changes it from a 4 to a 5. And so my question is, with this ordinance we're working on all this time, in my mind, was geared and aimed specifically towards Unit 4 temporary facilities. Once we start adding things to that, we change the definition.
When an application is made for a homeless shelter, part of the application then would include the term Group 4, right?
Correct, they would be Group 4, social
And in
service.
Group 4, those are establishments primarily engaged in providing temporary living facilities for individuals with personal and social problems. What was taken out was health care being incidental. So I guess my point is, trying to address what you're saying, Rex, is when you make the application for the homeless shelter, you're going to be in Group 4. So in your operational explanations here, you can't include rehabilitation of any sort.
Well, we do provide for ancillary uses within homeless shelters, which is later in the ordinance, I believe, approximately page 50 or 51, where you have personal services, chapel, social services, Group 1 and 2, transportation services. So on-site, I guess if you're saying on-site rehab is an ancillary use, we
Wait,
could
time out.
add that.
Yeah, time out real quick. And that is the purpose of this, let's get into the purpose of the ordinance, and again, the changes. The changes is the sections 1, the first part that we talked about, those are use groups. And the purpose of the use group is just to let people know that this is where it falls under our definition, under our words in the ordinance. Then the second prong of, so that just says, okay, now we have you defined. Now that we know what you're defined, what we're going to define you as, now whether or not you fall in there depends on, again, where you fall within that classification.
That's kind of what I was getting at, is that when you apply, you pick one of these groups, depending on what you're going to do.
Right.
This is a zoning ordinance.
Exactly.
And the point is, if I'm an entity and I want to do a social service in the city of Bonita Springs, and then I pick out what service, I want to look at your code under social services, figure out what use group I'm in, look at your matrix, see
Right.
if I have to get a special exception, see if it's permitted, or see if I have to go to a plan development rezoning, and then I would file my appropriate application. So staff has organized all the social services and put them in what they think are the appropriate use groups for the benefit of having that clearly established.
Thank you. That's kind of what I was getting at, is that is the process, and you explained that well. So once staff gets that correct, then we get into whatever you're doing in terms of operations.
But ultimately, these definitions will be in the comp plan as the definition for that piece of ground.
In the
The
land
use is
development
permitted
code.
for that
In
piece
the
of ground.
land
That's why it's important that the definition be very, very clear, because this is going to go on for
Right.
years and years and years, and it's going to be the use on that
Correct.
piece of dirt.
That's exactly right.
So it's important that it be correct.
Yes.
I'd like to make one last point. If you took the site on Old 41 North, the 10-acre site, which there was a development order application submitted for, and if they redid their application and showed a few rehab rooms, put in there drying out for alcoholics and so on, then they would be put down in that other group, and that would be permitted. That's what, I think that's what I'm trying to tell you, that that is a, for lack of a better word, it's a crack in the dike. Now, if esteemed legal counsels can say that's not anything to worry about,
As long as that's
I'm
in social
just telling you
services.
from what
Too.
I know of
That's
St.
meetings.
Matthew's House, you could argue that it's just as much a rehab center as it is providing temporary.
And let's go, let me go a little bit into federal law here. If a person is trying to get sober, and we'll use sobriety as an example
Right.
for this purpose, and sobriety could be from alcohol, it could be from drugs, it could be from whatever addiction that the person has. There is federal law, abundant federal law, that the act of getting sober, you know, not the conduct of drinking, not the problems of while actively drinking, but the conduct of trying to dry out, as we would use the old words, or, you know, going for sobriety, that is protected as an ADA. You cannot say, you know, so there's employment protections, there is living protections. Okay? So the way the ordinance is modeled is that if a person is trying not to drink, is, you know, in sobriety, or not doing drugs, is trying to do that, they can live in the facility. We're not regulating that. We do have a provision in the thing that allows, for example, meetings. In social services, is that group 1 or group 2, Alexis? Group 2, I believe. So that they could have, whether it's AA, whether it's different types of meetings, they can have the ability to get the rehabilitation at that facility. That's not a rehabilitation center. That is where, that's not where a person is going to deal with deliriums. It is a facility where a person has the ability to live.
Yes.
Did that help is that helping you?
I hear what you're saying. But it brings an interesting question to our definition here. If we are working with a group 4, a temporary housing thing, and just suppose this group 4 decided to have AA meetings there, would that constitute a rehab situation and change them into a different group?
And the ordinance permits the ability to have, whether it's AA meetings, whether it's a different form of therapy, has the ability to have that as an accessory use, and that's in, I think, page 49 or 50, Alexis?
51.
51? Okay, that was pretty good. Has it as an accessory use that they can hold those meetings at that facility.
Stop right there. Now, if they decide to do that, do they have to come to the city council, or who makes the decision that they can do that, or can they just go ahead and do it?
I believe Social Services Group 2, having meetings, I mean, I believe that's pretty much
In other
open.
words, we're increasing
We do it
the
in parks.
use. If they want to increase the use, how do they do that? Does John have administrative?
The
No,
code
sir.
provides
If
that
you are-
oh, I'm sorry.
See, if you are coming in under the operation and maintenance ordinance, if whatever uses you want on that facility or as part of that facility are included, they are reviewed and approved by the city council. Simply having an ancillary use does not shift your application,
Yeah.
your obligations,
Just
or your burdens.
specifically regulated.
It simply means that that is an additional use above and beyond what you're providing in terms
it's a group
of
two
a
use. That's
social
fine.
service, group 4 homeless shelter. So if you have a shelter and you provide rehabilitation, you provide meetings, whatever it may be, that
And these
is
are
an
support-
additional
to
use.
support
And
that
you still go
primary.
through that hearing process, you still go through that application process. Zoning board and council both hear and approve those uses.
And so in essence, it would be an ordinance situation for an increased facility, or increased use at the facility.
Yes, sir.
It's permitted, the facility is, the facility is permitted to have those meetings as an accessory use. So just like you have a retail store, there's accessory uses for retail stores. You have a parking lot, there's accessory uses for parking lots.
So you can go ahead and do it, and you don't have to do anything then.
No, sir.
That's how,
No, they
You're gonna
comes in your
require a special
operation and maintenance plan. It's all the uses that you are requesting go on into that plan. both location and a list, and that plan is reviewed by the staff.
But John, you
zoning
don't
board.
regulate and say, this church is allowed to have AA meetings and this church is not allowed based on.
What I'm saying is if you want to operate a homeless
Homeless
shelter
shelter.
and you go under the
Your operation
application.
plan has to list that you're having meetings there.
Yes,
So if we start out with one thing and want to add something later on,
they come back in and
they
request
come
that.
back in, and then is it your decision, or is it the city
Hearing
council's? And
Yes, sir.
and if it's a city council decision, then it's an ordinance situation?
I believe so, yes, sir. I'd have to
Or
check.
can they do that by resolution, or?
If they're amending their operational plan, I think some of that could probably just go to you. If they're saying, we're operating, let's say they're operating AA meetings and narcotics meetings, and then they never put down that they're doing gambler meetings, and surprise, surprise, a gambler loses their money, they're homeless, you know, and they never had a gambler before then. They're just amending it to have same type of
You would
thing,
basically,
different
they would
group.
basically require recovery-type meetings or.
So it's not a change in zoning per se, it's a change in the use that's already permitted, that
You
they've
have
already
two-
have
You have two
permits for.
separate items that you're discussing
Okay.
today. Right now is the zoning portion. So yes,
Mm-hmm.
there is a zoning portion. It includes the use groups, it includes definitions, all of those things.
Well,
are
once they
included.
fall under this ordinance, then, I'm trying to get clear in my mind, once they fall under this ordinance, and if they want to increase the use, what do they do?
The same process that they went through when they were originally approved. So that plan, that operations and maintenance plan that we have outlined in the next ordinance we're going to look at, they would submit an amended plan that would be reviewed and then approved by the
But
city
then
council.
ultimately, it's a city council decision.
Yes, sir.
Okay, that's what I wanted to know.
Yes, sir.
Okay.
If I can say, John, then that makes it makes all these tables that have been included here for use regulations very, very important.
Yes, sir.
I mean, that's what I find is the connection here is if the council approves, and you have the list here of all of the things that are approved for or how they go about getting issued a permit in different districts is extremely important. When you start saying, I'm going to add now to homeless shelters such and such. So what I'm located next to is very important, but that comes because you've zoned property a certain zoning, C, R, whatever it is. And that's what I was looking for here in the importance of why these groups are so important and how it relates to the use regulations for each of the districts.
Yes, sir.
John, how does the 1,000-foot rule, where do you measure from? Is it the property line, the center of the proposed facility, the outside envelope of the facility, what?
If you look at item, I believe it's B under that section of separation distances, it's the exact same definition that we use for consumption on premises, and it's from the facility itself to the property line of the separated use.
So but when you say from the facility, is it the outer perimeter of the facility?
Yes, sir, not the property line of the facility, but
The building envelope?
Yeah.
yes, sir.
So, Ms. Crespo, as I was talking about the different use groups here, the two that seem to be most contentious here is Group 4 and Group 5.
Depending on which version you're looking at, I would
The one that you had recommended.
say group
4 and 5, and could you say
3
that
and 4 really are the most contentious. 5 is that community group home, which is actually really out of the grasp of the city
Right.
of Bonita Springs. So it's
But-
3 and 4 is
So it'd be 4, and as we look at the tables of the different groups here, where do we find Group 5 as it's going to be zoned? What's kind of difficult to read, though, is when you have the first column is special notes or regulations, and then the other columns discusses the how you go about getting approval for that.
Well, to give a high-level overview, we changed the approval. It's not permitted by right in any zoning district currently. It would be a special exception process
Okay.
in your community facilities. It's existing only in your ag district. And then there's certainly the PD districts, which would provide for that through the PD public hearing process. But it's no longer a permitted use in any zoning district as proposed.
Okay, so this
And
group,
previously it was
right, so this group 4 is by special exception.
in your community facilities zoning district only. In other, I believe, and elsewhere it is either existing only or by the PD. Let's maybe go through the tables.
Do you see one of the?
Yeah, I see what you're
So the
saying.
intent there is to create a public hearing process for input and ensure that council gets to review those items.
Yeah, I guess what I'm driving at is that, public input really comes in when properties are zoned. And so you begin looking at these groups and what is allowed in these groups, so that when the application for a zoning or changing in zoning is made, you can get in front of what you may not like to see by understanding or approving what is going to go there or is not going to go there. And this has to do with land use. So I'm saying this is very important for that point, and these tables are very important because of that. And that's why I was trying to get a point across about where will we be finding the group 4s, and that's a special exception, and it's the ag zone property,
It doesn't exist at all anymore.
right?
Group 4, as I understand it,
Is not,
is not going to exist anymore. Except by special exception. I mean, it's not going
Oh, there will be a group 4, but correct, it's existing only in ag, not permitted in your residential, and then special exception in community facilities.
Okay.
And then not permitted in commercial.
okay.
So essentially, we're wiping it out as far as it,
You're, well, I wouldn't say wiping it out, we're requiring, most likely, it would trigger a planned development zoning. I think if you have 16 or
Okay.
more beds, you're gonna have the PD process, so there's the opportunity to ask for it and go through a process to,
well, that was our original plan 3 months ago when we started working on this, so that it would be regulated to planned development. order.
Right, that's what I was trying to get across here for the board, that,
I hear you.
kind of an overview of what we're doing.
yes.
Mr. Chairman, I have a suggestion when we do all these tables,
Okay.
and it's only because I have a real short-term memory problem, but once you do, let's look at page 9 of 55, where it says use regulations for 1 and 2 family. Above, on the very top, it has all of the zoning districts listed, and that's the last time you see them.
Right.
It would be really nice to have that little header on top of all the succeeding pages so that you don't flip through.
Yeah. At this point, I have not, I'm hoping when we have codification, it'll look a lot nicer. It's a lot harder when you're trying to draft it, because if you put
Right.
in one and then when we adjust the ordinance, I have to make, so on an actual codified copy, Municipal Code Corporation, it will read that
Every
way.
page will have the heading.
I hope so.
That would be a nice touch.
Yeah,
Usually do.
yeah.
Yes, I
So
think so.
that should be coming, fingers crossed, very soon.
Any more discussion on this item 5 from the board?
One question I have. One thing that has dropped out, and I think this has been on advice of special counsel, and I don't have any problem with that. Originally, it was proposed that any approval of any of these Group 4s, and I think it was Group 3s, would take a supermajority of council, and that's dropped out to where it's just a majority of council. I understand, this is my question, that we're going to go back, staff, legal counsel, and look at the different other uses and see if there's like a number of uses that should have that supermajority applied to it. Is that information correct or incorrect?
We took out the language of the supermajority.
Right.
And you want it back in after we said why we took it out, or would you?
No. My understanding, I thought my understanding was that later on, after these ordinances are adopted, the city staff would go back and look at not just social service,
Right.
but other things such as sexually oriented businesses, and determine whether or not it made sense on a broader class of uses that those
Sure.
would require.
And that's something, if we get direction to do so, we will.
Okay.
Okay, I'd like to have public comment as it relates to the amending certain social services sections.
The zoning ordinance?
The zoning
Or do you want
ordinance.
to do zoning and operational at the same time? Your call.
Well, we have it listed here for public comments after this section. Won't we do that?
Okay,
There's some people been waiting.
please.
I'm Deborah McLean. I'm the publisher of the Banana Peel, and I want to make sure I'm allowed to speak at this time about Mr. Forbes' suggestion that a group that is not an advocacy group for the homeless do an independent count. And I would like to set civil rights aside because I don't have any. I'm surveilled when I stop at a red light. I'm surveilled when I go to the bank or the ATM, to the grocery store, to the drugstore, to the convenience store. And my suggestion to avoid the pitfall of any count, which is a double count, because of the transient nature of a homeless person, that we stake out certain corners, just as a police unit would, 2 people per car, for a long, long day, for work days and weekends. Do it for 2 weeks, 2 people a car, probably 12 units, 12 cars, and take pictures. Don't ask people their name, take pictures. You can clearly see people coming out of the woods, jumping on their bikes and headed to the Cafe Life. You can clearly see them stocking up their bicycles at the pantry behind the wonderful Bonita Assistance Office. If you take pictures, you will not have a duplication, and it doesn't matter if they're living off a beach road because it's hot, or if they're inland when they want to be warm, or vice versa. The other thing is that an advocacy group does advocate for the cause and is not an independent approach. The stakeouts, including photos, would avoid the double count. I'm repeating myself. Again, food pantries, soup lines, and known areas. For instance, Bonita Isles, when they cleared the land, the homeless men rode their bicycles, had to find another place. So it is hard to find out where they are. I'm done. Thanks.
Thank you very much.
Good morning, Patricia Zimmerman, Cedar Creek. I would like to see the email that Ms. Vance is sending to the Homeless Coalition to have whoever is doing the count to ask these homeless, do they want to go into a shelter? As you know, many of the males in these encampments have said they will not go into a shelter. They don't want to follow the rules and regulations of a shelter. So could that be added by any chance?
Audrey?
I sent it, but I can just add that question here, and I'll copy you on it.
Thank you.
Thank you very much.
Good morning.
Good morning.
Linda Schwartz, Cedar Creek. I just wanted to support the suggestions of Fred and Deborah McLean in terms of an independent homeless count. And in addition to that, there is a homeless management information system. This document is 108 pages, and it details every data element that federally funded agencies are required to collect to get federal funding and to prove the effectiveness of their programs. And it contains 2 data elements that would identify where people live. One is residence prior to program entry, and the other is zip code of last permanent address. So with your permission, I'd like to email this document to you. I know John is familiar with it, but it would help you see how HUD is defining the various categories of homeless, including the virtually homeless, and how they're trying to avoid the double count, which some studies have not done. Thank you.
Thank you.
Thank you.
Let me ask, would the board like to have an email, or would not?
I'd like to have it from the city.
From
Okay.
the city.
'Cause
Yeah.
if I get a strange
Send it to
email,
Deb.
I don't open it.
Right,
So-
that's what I was getting at.
Okay, we'll make sure that the city has an older version of this
Thank you very
document,
much.
but I'll make
Yeah,
sure they
that's
have the
great.
most recent.
Any other public comments?
Carolyn Gallagher, Cedar Creek. I have just a few things that are sort of disjointed here. First of all, can you hear me okay? John had talked about how he got his 842 homeless down to the 30 for Bonita Springs. And my husband has been working on this problem too. And I'd just like to say that he's come up with 30 also, are within that ballpark using proportions and ratios and so on. So they're on the same wavelength. Second, I've had some conversations with Janet Bartos throughout January, and as we've decided, she did do the count as of the end of January, and it's due into HUD in April. And she told me, and I have an email on my phone, that it would be available probably sometime in March. The holdup is that each set of data taken by questionnaire has to be put into their computer, and it's very time consuming because, as you know, the questionnaire is more than one page long. She also said to me that she instructed her collectors to put Bonita Springs on the back of all the pertinent questionnaires.
That's great.
Good.
Very good.
So hopefully we'll have a little bit more accurate data, even though it won't be timely.
You don't think we'll get that before the 14th of March?
Doubtful? Possible?
Well, actually,
You've asked.
right, but I will say that we modified the time hearings. It does not appear that we have a quorum on March 6th, so the first reading will be March 20th, and the second reading by City Council will be in April. The first
Okay.
meeting in April is at the 3rd or
Okay, good.
whatever
Great,
the first
great.
Wednesday is.
Right.
Okay. My third thing is that I also agree with Fred that we need to do our own independent count, because I think that's very crucial. The whole issue rests on how many homeless do we really have in Bonita. So I can't reiterate that too many times. We do need our own count, and it needs to be an independent one. The other thing, back to the zoning, on my copy, page 50 of 55, section 4, dash 3075 on development standards, in parentheses D, and it talks about group 5, and it calls them community residential homes. I do want to say that may be a little confusing because page 4 calls this group homes. So I suggest changing that residential to group to be consistent with what was used previously. And if you have that, I think that concludes.
Let me ask again, you mentioned page 55?
Well, and mine, it's under section 4/3075, development standards. On my copy, it's page 50 of 55.
It's on 50.
Oh, okay.
50, that's
50 of 55, that group.
And which section again?
D?
It's down under D. It says Group 5, community residential homes must be cited in accordance with Florida statutes, blah, blah.
Right.
419.
Earlier, on page 4, they referred to the same group as group homes. So I think that to be consistent, we need to change that word residential to group. I talked to,
Okay.
okay,
And I just need to look at the statute. Let me pull 419 and see which word they use.
well, whatever they use, we should be consistent, is
Right,
my point.
exactly.
Right,
Yes,
yeah.
okay.
I think we agree on the point, we just not sure.
Right,
how to
exactly,
fix it.
yes.
Good eyes.
Good.
All right.
Thank you.
Thank you.
So, we bring statute.
Any further public comment? Right now, I think I'd like to take a break here for 10 minutes, if it's okay with the board.
Sure.
I think we have one other,
Oh, someone else?
I'm sorry, I forgot to add, there is a seasonality. We have heard 16, 30, and 36. There is a seasonality factor. And if people do need help, I'd like us to do the count at the peak of season when we have a peak homeless population. That's it.
Okay.
and the term in statute is community residential homes. So we'll change that in group 5 to community residential homes.
Okay. Thank you.